Okay, Attorney Steve, we're back. This is foreclosure defense. These are some possible grounds over the years that we've looked at in trying to stop or reverse foreclosure sales. So I'm going to give you a general overview. This is not legal advice. This is general legal information. If there's something that is basically designed to help jog your thought process into thinking, are there certain things that maybe I should be looking at if I'm facing a foreclosure? If you want an unbiased review of your case, we do offer paid reviews, and we will give you an honest and objective advice as to where we think your case is, what you're looking at, what your possible defenses are, what your possible options are. There's a lot of attorneys that give free consultations. Well, what happens a lot of times when you get a free consultation is you have somebody that's trying to sell you something. They then, when they spend an hour with you, 2 hours, whatever, then they have to sell you to make money. So they may be telling you things that you don't need to know, you don't need to do, and they may talk you into things that you actually don't need. So I want you just to bear that in mind. This is general legal information. Let's get going. Warning, fraud. Excuse me. Warning, this is not legal advice, not a substitute for legal advice. General ideas. And some of the accurate information may not be accurate or current, as information is always changing. Okay, SB 94, first most important thing, SB 94 was a law that was passed in 2009 that says lawyers, law firms, law centers, foreclosure consultants, nobody, paralegals, nobody, religious centers. We've had religious centers that think, well, it's my First Amendment right to practice religion, and so I'm able to do loan modifications. No, Okay, so if somebody is trying to charge you in advance to do a loan modification in the state of California, your first response should be, heck no, not going to do it. Okay, SB 94, illegal to charge. Do not do that. Okay. Injunctions. One of the important things about an injunction is if you're facing foreclosure and you're getting shenanigans from the bank or the loan servicer, which is very typical, if they're basically dual tracking you, putting you through foreclosure while also considering you for a modification, you need to get an attorney involved. Do not trust your bank. I repeat, do not trust your bank. They cannot be trusted. I can just tell you that dealing with banks year after year after year, is if you're facing that foreclosure, and sometimes it's overload, they just have too much going on, or they're not paying people enough to give a darn. If you're in that situation and you believe that they're going to foreclose, if you're not sure, call, get an attorney involved, because it's harder to turn a foreclosure sale and reverse it than it is to stop it. Okay, so repeat, if you feel you have grounds, stop it in advance, seek an attorney before your sale. Okay, in Arizona, as it says here, there is actually a statute, 33811C, which says if you don't seek an injunction, then you waive it. If you're not seeking defenses to the sale, you waive it. So there are some exceptions in case law and this and that, but point is, you don't want to get yourself in that point where you're testing the law. Okay, top 10 things to look for. One, it's not on the list, but this is new. This is the Homeowner Bill of Rights. This is where they're dual tracking you, foreclosing with robo-signing, those kinds of things where you have rights if there's a material violation of the California Homeowner Bill of Rights. First and foremost, that's something that you want to look for. If you prevail on that, if you're able to seek an injunction, you're able to seek your attorney fees. Okay, so this is something the banks have to be concerned with and consider. Other things that we have on the list, 17200, which is California's unfair competition law. This is found in Business and Professions Code Section 17200. The Fair Debt Collection Practices Act, RESPA. These are statutes. The 17200 is a California state statute, while the FDCPA and RESPA, which stands for the Real Estate Settlement Procedures Act, those are federal laws. Okay, so those are grounds to look at where they're violating your rights. And we'll talk real quick about a debt collector. If a loan servicer acquires your debt, your loan, after you're in default, then they're considered a debt collector. And you'll see debt collector on the bottom of their letters that they send you, their monthly statements or whatnot. They'll say, this is an attempt to collect the debt. We are a debt collector. What we like to do is send in debt validation letters demanding that they prove they have the legal right to enforce your note and to produce the note, to produce the endorsed note, and fight them and say, I want proof that you are who you say you are and that you have the right to enforce that debt. Under the Fair Debt Collection Practices Act, you can try to seek an injunction. This may not be the easiest grounds, but again, when you're desperate and you're fighting cancer and you can't move out of your house, you have ramps and rails in your house for your disabilities, hey, sometimes the rubber hits the road and you've got to pull out all the stops. RESPA, again, is a statute designed for, say you send in a qualified written request. And we have videos out there on qualified written requests. These are very important. It's basically a written request in writing to your loan servicer making an accounting or billing dispute, saying there's something wrong with your accounting, your billing, you're charging me fees, you're packing it, you're doing this, well, you're not telling me what my payoff is. Believe me, this happens all the time. A qualified written request under RESPA right here is you need to put that in writing and they have a chance to respond. If they're not responding and it's before the sale, you may want to be asserting that and explaining that to the judge what happened. Okay? So we have other videos on qualified written request. You can Google Vondran qualified written request, see what you find, and contact us again if you need a consultation. Best place to contact us, by the way, is 877-276-5084, or find me on the web at attorneysteve.net. That's attorneysteve.net. Next one, foreign language contracts, Civil Code 1632. Okay, if a lender or loan servicer was negotiating and targeting certain minorities in negotiating the contracts in these 7 protected foreign languages in California, and the contracts were not in that negotiated language, you may have grounds to rescind. Okay, now this gets a little tricky. There's different areas with whether it's as to the broker, the lender, but this is something, again, to look at if this may be an issue in your case. Failure to follow statutory requirements is the next one. These are things like your 2923.5, reaching out to you, seeking to help assess your finances when you're facing a foreclosure. Again, the California Homeowner Bill of Rights of not dual tracking. This includes things like 2924, Section 2924 of the Civil Code, which talks about the foreclosure process. This talks about your notice of default, your notice of sale, your substitution of trustee. If they're not substituting your trustee, if they're not recording the notice of default, the notice of sale, these are things to look at, okay? TILA rescission. What's TILA? TILA used to be one of my favorites. The Truth in Lending Act, the Federal Truth in Lending Act. Okay, so you have 3 federal laws basically that you're going to be looking at. Your FDCPA, your RESPA, and your TILA. These are your 3 laws that apply to the mortgage lenders and the banking industry, and 3 things that you have to use in your toolbox here. TILA rescission, when you have material violations in your loan documents, and trust me, whenever you have a neg-am loan, option arm, pick a pay, pick a pray, whenever you have these kinds of things, they normally will have material violations. We used to audit loans, and trust me, they were there in a lot of cases. About the only exception to that would be a prime loan, where basically everything was done right. It was a 30-year fixed, full document loan. Then maybe we didn't have problems, okay? But TILA rescission gives you an extended 3-year right to rescind your loan. Let me repeat that. It's an extended 3-year right to rescind your loan. And it doesn't go beyond that. A lot of people try to say, well, Attorney Steve, can't we toll it? Can't we, isn't it the discovery rule? I just found out. No, courts aren't going to go for that. Courts are strict on this as it is. We have videos and blogs out there. A good place to go to see one of my blogs in this area, rescindmyloan.net, rescindmyloan.net, with lots of information about TILA rescission there, okay? But keep in mind, it's only going to go back if your loans are 3 years back and you have issues about whether or not you can tender or make an allegation that you can tender the balance of the loan. those are some things to look into. Again, these are issue spotting. These are things that you want to be aware of when you're facing foreclosure. Again, we talked about the substitution of trustee. Here's the 17-200 again. I actually don't need it in there twice. But elder abuse, you have financial elder abuse, socking elders being 65 years and older, socking them away in these unconscionable loans. That's something you want to look at. Financial elder abuse is the wrongful taking of personal or real property of an elder in bad faith. There's cases on that. I'll give you the one to look up if you're in this area, is the Zimmerman case. And give us a call, by the way. We have a good history of helping elders in financial elder abuse cases and litigation. So that's something to bear in mind. Lona versus Citibank is a very important case to have out there, dealing with unconscionability of loans, challenging the very validity of the loan itself. And Lona versus Citibank was a good case because it talked about unconscionability and the requirements of tender. You don't have to tender the loan balance. If you've done any litigation in state or federal courts like I have on these cases, you'll always get what I call the lender tender rule. Oh, lender, please don't make me tender. And so a case like Lona versus Citibank is a good one for you to point out. There's also the Humboldt case. These are cases you want to use in your arguments to give the judge something to hang his or her hat on. You have the Consumer Legal Remedies Act. That's something that I'm not going to go into in detail, but you have where merchandise isn't sold and as it's advertised, you have rights to look into the California Legal Remedies Act. That's going to be a separate thing. You have the Civil Service Members Relief Act. This applies to foreclosure cases and where you have military members and there's certain requirements that the lender must go through. I don't get a lot of these cases, so I can't go into detail, but that's something to look at. Another area where we have a lot of injunctions and where the courts are willing to give injunctions is where you have these modification agreements and the lender agrees to modify your loan. And then they transfer your loan off and the new servicer says, no, we're not going to follow that. That's a securitized loan and they didn't own the loan, or we just figured out somebody else owns the loan, so we're not going to honor that. Okay, or where you sent your payments in, trying to exercise your right to reinstate your loan, and the lender says, we couldn't find your check, we didn't get it, or we foreclosed anyway even though we cashed your check. Those kinds of things, okay, are important to look at when you're facing a foreclosure, trying to get an injunction. Again, do it before the sale. Don't wait till there's a foreclosure. Once you wait till a foreclosure, you're really putting yourself in jeopardy. I make a note here about the produce the note or show me the note. This is not grounds to get a civil injunction, even though you would ask for some of these things in your QWRs and your FDCPA letters. It's not a ground for civil injunction in the state of California. And the way the courts feel about this, and there's been tons of cases on it, is even if they don't have the note, it's a private trustee sale. Hey, sorry, don't know what to tell you. We need to allow the bankers to do whatever they want to do. If Walmart wants to foreclose on you, then Walmart gets to foreclose on you. So unfortunately, that is where the state of the law is now, pending any other outcomes. Another thing, MERS, a lot of times we have people want to basically say, MERS, I've got a MERS loan. Well, MERS has been challenged in every possible direction, and really the big case was Gomes versus Countrywide came down and said, hey, you signed and agreed to MERS, you signed the deed of trust, so if they want to be a nominee, they could be a nominee. If they want to sign the documents in behalf of their own name, which we see them do sometimes, not even in the nominee capacity, hey, it's, pay your mortgage kind of thing. So those are something to be aware of. The grounds for injunction in California, you go to court, basically when you're trying to get an injunction, you're going to be filing a complaint. At the same time you're filing a complaint, you're going to be filing for an injunction. You're going to be setting forth the grounds. For example, the grounds I just set forth. So one of these or some others. There are other grounds, by the way. That was not an exclusive list. Those are just my top 10 for getting an injunction. But you need to show the judge. It's your burden as the person trying to stop the foreclosure. You need to show the likelihood of success on the merits. Sometimes it's a strong likelihood of success. You need to convince the judge that you're going to win. You need to show that you're likely to suffer irreparable harm, that money damages alone are not going to suffice. This is your home. This is where your kids live. This is where your amenities are. You need to show that the balance of equities, the fairness of it, tips in your favor and not theirs. And sometimes you need to show that it's in the public interest. So those are the things you're going to be arguing. There's lots of different cases that have different variations of this test, but that's the basics. And in essence, you're going to go and try to get the injunction and basically convince the judge that you're entitled to that. If you get it, typically you may have to post a bond, and after the injunction is granted, which is usually for 10 days, then you're looking at trying to get a preliminary injunction, which would be an injunction that would be in place for the duration of the lawsuit. Okay, so that's how it works. So that's what I want you to be aware of. If you don't get the injunction, you still have your lawsuit, so you can still trudge on in the litigation and whatnot. But that's the basics there. So I think that's about all I'm going to go into for now. I've got other slides, but if you want to find out more, this is Attorney Steve Viner, and I'm licensed to practice law in California and Arizona. Been fighting for homeowners and predatory rights, predatory lending, predatory loan servicing for the last 7 years or so. We've been in the trenches in state courts, federal courts, adversary proceedings, and bankruptcy courts, and we're here to fight for you. We're also here to give you objective advice as to whether or not you should be fighting. In some cases, you should not be fighting. You should be thinking short sale or bankruptcy or walking away from your property. Okay, so give us a call, 877-276-5084. I hope this video has been helpful. If you like it, feel free to share it, pass it around on your social networks. Just trying to do some good out here in the world. Okay, everybody, take care. Have a great day. We appreciate your visiting.